I explained a little bit earlier that when you are starting this process, you've made a decision, you've chosen a lawyer, you don't need to know anything about what the legal documents are going to be. But in this third phase, this third step, when you're working with a lawyer, this is when you need to understand, are they recommending for you that your estate plan be based upon a will platform? By that, I mean that it is not going to be a revocable living trust. There's basically two fundamental platforms for your estate plan. Either a will, which will likely go to probate, or a revocable living trust, which intent is to avoid probate. And is one better than the other? I can't answer that because I don't know your particular situation. I can tell you that if your goal is to avoid probate and there is no reason for you to try to protect assets for your surviving spouse against long-term care, even in the state of Washington, then in that case, we would likely agree that the revocable living trust is the right path forward for the client. How did we know that? Well, we got to that by understanding that they wanted to avoid probate. They wanted to make things simple. They have no need for protecting assets against long-term care costs. And that tells me that they likely have long-term care insurance or over $1 million plus in assets, because that is a more appropriate situation to have a revocable living trust in Washington. In Washington, by the way, probates are non-intervention. The fees are not based on the size of the estate. Probate is pretty a simplified process here, unlike other states. If the client's situation is such that they perhaps don't have long-term care insurance, they don't have ample assets, well over $1 million, and no matter what their age is, they're concerned that the surviving spouse might become impoverished due to long-term care costs. In that situation, we may well recommend a will-based platform. What that means is if the situation calls for a probate on the death of the first spouse, we would recommend a probate. And you may say, why are you recommending a probate? That costs more money and it's more work. And I thought I was getting my affairs in order so I would make things easy for my surviving spouse. There is a trade-off, there is a balance. Let me just give you a very simple example. And like I mentioned, I don't want to delve too much into the legal documents, but I want to help you understand that where, let's say we have a couple, they're in their mid-60s, 70, they don't have long-term care insurance, and they have $1 million in total assets. And whether or not they have a diagnosis or not, they're at an age where long-term care is probable, unfortunately. So we would probably include a mandatory supplemental needs trust. And what that means is that on the death of the first spouse, their assets, half the estate, $500,000, goes through their will, through a probate, into an asset protection trust for the surviving spouse. $500,000 is in a trust. Why did we do that? That money in the trust will never count against the surviving spouse should they need long-term care, so that Medicaid doesn't count that money as belonging to them. That's a nest egg. That's a safety net where we know that that surviving spouse will always have available and not subject to long-term care spend down $500,000.